is a boutique technology-driven commercial, corporate, and online legal service. We serve the unique legal needs of startups, content creators, sports sectors, entertainment industry, pharmaceutical, biotechnology, agriculture technology, and this is done in a fast, cost-effective, and timely manner. NetSheria, through its Entrepreneur Club and Documents Portal offering, focuses on using technology to help entrepreneurs direct their passion and vision to their core businesses as we handle the legal stuff. We offer the voice of business experience. We offer the voice, a guiding hand to startups and young companies as they develop their products and services and successfully scale up and move them to market. Our three main areas of practice are commercial law, corporate law, intellectual property and technology, media, entertainment, and communication. We provide affordable legal documents and online consultation services from our team of established lawyers who will basically take care of all your business as usual, legal work, as you take care of making the money. NetSheria International, your lawyer on your laptop.
Good morning, ladies and gentlemen, and welcome to this webinar today on this morning of 29th November 2023, hosted by NetSheria International. We've just run a short video. Sorry for starting late. We've just run a short video to introduce NetSheria International to you. And today we'll be tracking a very interesting topic that has come up in the business area in Kenya, which is the area of cloud computing, and specifically dealing with cybersecurity and legal agreements. I think a lot is said, a lot is heard about storage on the cloud and the use of such terms. And with the advent of the business has gone with e-commerce and the movement of a lot of e-commercial transactions to the internet, there's been a lot of focus on use of online storage facilities for data, for communication. And we thought it fit to have this webinar to break down this area of cloud computing and have some insights from established players in the industry, as well as look into the legal technicalities of cybersecurity and legal agreements and how they can apply to companies that are involved in cloud computing, both from the user end and from the end of the companies providing the cloud computing solutions. So today with us, we have a very interesting panel. I'm your moderator, Njomo Kamau. I'm the director of NetSheria International. And today we will have the main speaker being Simon Ruto, who's an associate advocate at NetSheria International. He's a tech specialist lawyer. He's an advocate of the High Court of Kenya. He's a tech specialist lawyer who's passionate about technology and emerging tech spaces. He's currently enrolled in a cloud engineering and data analytics course with Azubi Africa, and is also set to start his LLM in ICT and telecoms law. Welcome, Simon. Also with us, we have Mr. Baiju Shah, who's the Chief Executive Officer of eBiashara Limited. He's a client of NetSheria International. eBiashara is an e-commerce company, and he's an expert in the finance, blockchain, and telecom markets, and has vast knowledge and experience in telecoms tech, fintech, edutech, game tech, e-commerce, digital marketing, and cybersecurity solution technologies. And so we thought it best to have a practitioner like with his standing to join us on this webinar to take us through the intricacies of e-commerce in the business world. So without further ado, we'd like to get right into it. Maybe I can ask Baiju, maybe you can unpack for us what these developments in the e-commerce industry, with the increased uptake of cloud computing technology by businesses in their operations, and what it really means for businesses going forward in this new climate. Over to you, Baiju.
So, good morning to everybody. Sorry, we started a little late. Some of it to do with me. trying to log on. Again, a technology challenge at times. Okay, in terms of cloud computing, in terms of e-commerce, first of all, we'll talk about e-commerce a little bit. And with COVID setting in, everybody started transacting online immediately. So what I mean by online is you were working from anywhere, everywhere, and you were getting deliveries to you. So it might have been a work package delivered to you, or it could have been a product delivered to you. So that whole delivery aspect of product started with you ordering from a screen or a type of a device, right? And from the other side, we also look at the cloud computing giving us the scale, the scalability, and the outline around security as well. So, if you have thousands of people who are on a shared service base, offering the security aspects, the scalability aspects, and the aspects of cloud computing becomes extremely viable. The other models which started to establish were models around software as a service or a platform as a service. So you were renting more out than buying servers, installing servers, because you had nobody left to go and install those servers and maintain those servers in your local hosted data centers or mini data centers in your companies. So most people tried to move to the cloud, and you were getting services there. Yeah. So that's where I am. Thank you.
Thank you, Baiju. Thank you for those insights. And we'll be looking forward to learning more about how the cyberspace has evolved, and the use of cloud computing is continuing to grow in the business usage in this country. So maybe now we've been hearing a lot of captions, hashtags like cybersecurity, cloud security around tech, and sometimes these phrases sound very technical, and sometimes they can hide the technicalities of the intricacies of the law that surround them. So maybe over to you, Simon. You can just take us through and explain where does this cybersecurity cloud computing come into the law, and how does the law basically cover these areas in the operations? Simon, over to you. So you seem to have lost Simon temporarily. Maybe while he's still coming back on board, maybe Baiju, given that introduction you gave us about what cloud computing entails and cybersecurity, could you maybe just touch a bit on how cloud computing helps businesses meet their objectives, how it can help them scale, the benefits to the business, and how it would actually foster innovation going forward?
So very interesting insights, right, on cloud computing. So I'll give you a very good example. End of last year, we had a client come into us, and some of you might know Kenya Broadcast Corporation, KBC. They came into us and asked us to build a OTT app, a streaming OTT app for the World Cup content, which they had contracted somebody else who failed to build. We built it in 6 days using all cloud tools from AWS. So time to market is very important, but providing that security around the content as well, enabling pre-built workflows available on the cloud, which you could use to launch an MVP. So we launched an MVP for ABC, for example. So that's the strength and the power of the cloud. So think about bringing on a commercial application from scratch into fruition, trying it out, collecting a payment or collecting a subscription behind it, and then being able to remit and provide all of that and the scale around it. So when we did the final, we had about 80,000 concurrent streams on the final match, for example. So from zero to getting to that point in 6 or 7 days, and then having another maybe 3 or 5 days to sort of set it up correctly and then go to market. So that's the power of the cloud, literally. In terms of security, we were able to geotag the content, protect the content, and be able to make sure that nobody copied the content and align to the requirements or the constraints which are set up by the FIFA guys. That's an example. I think it's quite vivid in my mind. And of course, NetCarrier helped us to put all the contracts together, for example. In that 6 days was manic. I remember it was near Christmas, right? Nearly about this time.
Yes, that's true. So around that time, and we had to come up and put all those contracts together for you. So it's good. I think sometimes as lawyers, we do the documentation and we don't really appreciate the impact of this documentation in the actual business world. And there's always a line to be drawn, some connection to be made between the drafting of the documents and the actual application on the ground. So maybe while you're at it and as we wait for Simon to come on board, I just want to invite the attendees today. You can also raise your questions. We'll be taking the questions. You can raise your questions on the chat box on the Zoom platform, and then we will take them at the end, or as they continue to increase, we'll be taking them on a case-by-case basis. So maybe, Baiju, again, still as you wait for Simon to come on board, you've said that there's an issue of business success in terms of profitability and technology, which I enjoyed through this kind of relationship between the actual usage of cloud computing on the ground and the legal support that's given. But where the profits, of course, the buck stops with ensuring the risks that would have business profits are kept at bay. So maybe apart from those traditional risks, how does cybersecurity come into play in protecting the business from the tech risks that people are unaware about?
So for cloud, think about it this way. So if you run an on-prem deployment yourselves, on an on-prem deployment, you might put on a firewall, you might put on some amount of security, you might put on some protocols around it. But when you start to look at a cloud computing or a hyperscaler, they provide you a pre-built security. They have world-class security experts who are monitoring your network and protecting your network, for example. Then your role becomes to protect your application, and then the application, they provide you with certain amount of tooling, certain amount of analytics, certain amount of alerting, which is pre-built into the whole mix, which helps you to accelerate the protection, because to get that knowledge in our market is very difficult. To build that knowledge takes time and a huge amount of investment. So the hyperscalers are giving you a pre-made solution, pre-built. So it's like the example there is, I want to buy a car. And when I want to buy a car, I don't go and make my own car, do I? Or I don't buy the bits and pieces of a car and put them together, right? I go to Toyota and I get a full car with specifications, factory fitted, right? Maybe I might add a stereo system of what I don't like. So that's the difference in buying certain services out of the cloud, and that gives you your security stance, which is world class. I don't think us as EB Ashara ourselves will not be able to put a defense on those bases, but with help of our hyperscaler partners like Microsoft and AWS, we tend to take those world class services. So again, coming back to specialist knowledge, specialist know-how, and built into technology itself. Thank you.
All right. Thank you, Baiju, for taking us through that and helping us to get that connection between the cybersecurity and how it actually comes into play to minimize those the tech risks for the business. So maybe Simon, over back to you. I think now you're back on. We were talking about the fact that there's so many hashtags and terms which are used in this area of cybersecurity and cloud computing, such as those terms themselves, and being used around tech. And of course, most of these things should have a legal basis. So we thought maybe you can take us through, because they sound very technical, maybe you can take us through how the law applies to these fields and operations, and give us a brief as to what the underlying laws for this area of operation is.
Thank you, Jomo. Thank you, ladies and gentlemen, for joining us today. My apologies, we've had a technical challenge. Well, in terms of the law playing in on cloud security, cybersecurity, and such, it normally comes in to just ensure the substantive aspects of the law as well as the procedural aspects are met. This is in line to do with the law coming in to actually provide the body of what should be entailed in terms of running the cybersecurity aspects in terms of the cloud computing, and while at the same time providing for the procedural aspects whereby the law then comes in to regulate the market itself, regulate the use of computer. This has been the case, especially to do with, for instance, the cybersecurity, the Computer Misuse and Cybersecurity Act, for instance, which is the main body of law that comes in to regulate the use of computers. So the law basically just comes in to provide the aspects of checks and balances in terms of the use and regulate on how, say, settlement of disputes can arise, if they arise, and how this can be regulated. Thank you.
Simon, I have a question for you on a slightly different note. How does the law treat a mobile device versus a computer? See, there are two different aspects to both, two different uses as well. So how does the law deal with convergence? And maybe everybody around us might want to listen to that. Sorry, I put a spanner in your works, as they say.
Sure, Baiju. In terms of the computer and the mobile phone, you'll normally find that mobile phones of the age actually have operating systems that feature the initial computers that came quite early before. So you find more or less it's still the same operating system. Now, how the law then comes in to regulate this, you'll find both computers and mobile phones are normally both used in terms of the telecommunications aspect. I mean, you can make a phone call through your computer device, the same way you can still make a phone call on your mobile device. So the law, especially to do with the current Kenyan law, doesn't really quite provide the differences, if I may use the word, for the provision of how you can use the computer and how you can then use a mobile phone. The major aspects where the law then comes to sort of differentiate this is in terms of the regulatory aspects. For instance, the Computer Misuse and Cybersecurity Act, yes, it delves into the use of computers, but when it now comes to the aspects of using your mobile phone, this is where the law comes in terms of making the tariffs for like the communication authority provisions that came in the other day to regulate on how you can then make a phone call, the costs of using from different service providers, as well as the tariffs that it charges to ensure that these mobile service providers, or rather the telecommunication companies, then do not really overcharge a consumer. So it's more or less, non-distinct in terms of using your computer and using your mobile phone, but this is now subject to changes with the law. You'll notice one thing with technology tends to evolve way faster than maybe how the law does. So in terms of our Kenyan development of the law, you find it's really not distinctive as to you using your computer or you using your mobile phone, because for cybersecurity attacks, for instance, if I decide to do, or rather somebody mischievous undertakes to do phishing as a cybersecurity, as a cyber attack rather, the same way can be done on a computer is the same way it can still be done on a mobile phone. Thank you, Bajan.
Welcome.
Thanks, Simon. Maybe as you also touch on that, I think a lot of people also want to understand how the law correlates with these tech advancements in the running of business. So how does the law further interlink and blend to have that seamless operation?
So while both the law and technology tend to correlate widely, especially in the current age, you tend to find that for most cases, the law then comes into the play of trying to regulate what really takes on in terms of you running your business. And this can be in the sense of, say, in finance law, in financing, or rather in the finance aspects of you running your business, there is the fintech aspect. In terms of education, for instance, if you're running education software, there's the edutech aspect. In terms of maybe telecommunications, this is still there. So all this can be coupled to the e-commerce aspects, whereby then the law tends to come in to basically provide, as I mentioned before, the aspects to do with the checks and balances, whilst ensuring that the consumer or as the end user is protected, while still ensuring that the business in terms of maybe the intellectual property aspects of the business are protected, like say to do with a cloud service provider, that is the part that there are scopes of intellectual property that come in, while at the same time there is the end consumer. Where in between you find, like I've mentioned, the mischievous subjects that come in to carry out cyber attacks. So the law then comes in to protect the use of computers, the use of the technology, the use of operating systems, the use of the cloud computing softwares to now cover both parties and ensure that the business aspects are protected. So essentially, it then merges the business, the intellectual property, the consumer on the other end, and ensures that all their business objectives, all their end user objectives are protected and met at the same time. So basically, the law sort of overarches all the three. Yeah, thank you, John.
Thank you, Simon. So I think we've talked a lot about the law and how it connects with the tech, these tech developments. But I think it's agreeable that, of course, then the tech and running of business then also run concurrently with the support of the law, but they also complement each other towards the realization of profits for the business, increased profits for the business and for the business owners. So beyond the tech risks, maybe, Simon, are there any other logical explanations for developing the ethical use of technology and ethical running of businesses towards enhancing the growth parameters?
Well, I can capture some aspects that provide for the argument of the law coming in to merge technology and the running of businesses. For instance, we can all agree that businesses are the economic drivers and the gross domestic product indicators. So you tend to find that in terms of running the business, or rather businesses running, they tend to provide the overall performance of a given market. So let's take the Kenyan market, for instance. Businesses tend to provide a background view of how the economy itself is actually running. This will then provide an aspect of how the business environment itself is, as well as the social scopes of the progress of a given market, like let's say for instance, the Kenyan market. On the other side, there is the argument for corporate responsibility. You find that it is true that for businesses to run, they ought to carry out their businesses in a more responsible manner by, for instance, ensuring that consumer protection aspects are met. At the same time, ensuring that the business itself runs in an ethical manner, that you don't really infringe on the law, whilst ensuring an overarching aspect of you running your business ethically, whilst ensuring that consumer protection is met, ensuring the aspects to do with the products that you provide are actually ethical, the way you run your business is ethical, whilst also ensuring, for instance, the supplier part of the business, you've catered for, you've paid your bills on time, you've been able to adhere to the law, you have the proper licenses. So all this come down to the aspect of corporate responsibility as an argument as to how the business and technology tie down together. There can be also the aspects of the feasibility aspects of business against business sustainability. So are you just running your business for the idea of making profits? Are you using this technology without giving the interest of the parties involved therein? You find that there's the argument of you running your business without, for instance, ensuring that you're all playing from an equal parameter in terms of maybe information asymmetry. By this, I mean, for the consumer, you ought to provide maybe details as to the products they're getting. For the supplier of a given software, a given device, they ought to then provide for user guidelines. So all these arguments come to boil down to, other than you engaging in the technological risks that come when you involve technology in your business, there is the argument of the feasibility of you running your business whilst ensuring its sustainability. It is not really just about making profits. It is also ensuring that your business is run in a manner and way that all the three aspects tend to come and play in terms of ensuring that you're making profits on this other end, the consumers are protected, your suppliers of software and your use in the business are all in uniform and towards the main business objective of making profit. Thank you, Jomo.
Thank you, Simon, for that explanation. I think now we can also get a bit more technical. Baiju, you talked about the kind of software. You mentioned that there are certain softwares and technologies which are now used basically effect this or implement this cloud computing and cybersecurity solutions in the country. And I know as Biashara, these are an area that you operate in, and you must provide some of these services and solutions to your clients. Maybe you can just give us a brief summary as to the kind of cloud computing services that you provide, and then we'll also then hear from Simon about the supporting agreements which are used to complement services. Over to you.
So thank you, Jomo. A very, very intriguing question, because generally what we see in the market is a lot of companies, especially in the especially the IT departments, get onto the cloud thinking it's going to be low cost, I'm going to save money, but do not train enough and do not know how to operate into the cloud. So take an analogy of, you've learned how to drive a manual car. Now you're put in a huge truck, which has 20 gears, and you're supposed to drive from Nairobi to Mombasa. In the manual car, you will make it because you've been taught, you know how to operate it. Now, truck, which is fully loaded, and think about the cloud computing as a huge truck, right? Which is fully loaded with a lot of things. You don't foresee a lot of things going wrong, and then you get a big bill at the end of the month. So you go to your management and you say, hey, this cloud computing thing is too expensive. Not saying that I didn't know how to operate it, right? You've rolled the truck. By the time you've gone to Mombasa, you've lost most of your data on the road. Think about it that way, right? So now coming back to that question, and I've set the scene, is that when you get into cloud computing, or when you get into what we do and what we are doing and insisting now is we offer a free assessment to anybody who wants to get into cloud computing. We set up a meeting, we'll spend some time with our experts who will come and give you a free assessment. It'll cost you nothing. It's just us coming in. If you might want to sign an NDA, we will sign an NDA. This is a bit of a community service we do for everybody and anybody, pretty much, because we think it's the whole fraternity. Again, as data sits into imagine you have control of data yourself when you have it in your infrastructure. Literally, you don't, but you assume that you have control over it because you're closing your ports, you're opening your ports, technically speaking, and you have somewhat control. But if you go to the cloud, you can't see it, right? It's intangible, right? But all of us use Gmail, right? Who doesn't use Gmail here, right? Everybody uses Gmail. I use Gmail. I've been using it since 2004, and I trust that my Gmail will always work. Isn't that on the cloud, right?
Yes.
Think about it. It is on the cloud, right? And why do you trust it? It's all about trust. Why would you trust that over your own email server? When I send an email to somebody and say, oh, I didn't receive it, right? The next response is, can you send it to my Gmail box? Correct? Have you done that, Simon?
True.
Yeah. So there you go. So there is trust in the cloud, and how businesses are looking to move there is another criteria. So you have cloud native applications. What do we mean? Those pieces of software, those pieces of applications designed to go and fit into the cloud. So it's like when you go to a store where you're buying a suit, which I had the experience of the other day. You have to try 1, 2, 3, 4, maybe 5 before you fit into something correctly, right? Cloud computing is very similar. You have something on-prem, and you have to, when you move onto cloud, you've got to go and re-architect, refactor, migrate, lift and shift, depending on what you require, right? And what the fit is. If you have legacy software which is flexible, then you refactor or re-architect, and you come up with a legacy to a modern system as part of your migration. Or if your piece of software is very, very stringent, it doesn't give you the flexibility to do anything on it. Cloud guys call it lift and shift, right? So you have a server which you have in your back office, or you have a server in your mini data center, or you have a server in a local data center and you move it onto the cloud. The couple of things which come with it is your responsibility and your change in operations. Most companies fail to change that operation. Most IT people fail to train. When all of us went to school, we learned IT. Our lawyer friends learned the law and how to apply the law. It's the same scenario, right? So look at it that way. And I think that should set the scene for Simon, for you to give us some some comments on how law is applied to technology and how technology is revolutionizing law. I mean, you have AI coming on, you have things like ESG coming on, and how is the legal system supportive, not supportive of all of this? Thank you.
Thank
Well,
you. Thank you, Baiju. And maybe Simon, before you answer that, I'm seeing a comment here, which maybe before we cross over, there is a question here from Mr. James Mutiso, who's saying that since cloud users do not have direct control over the physical infrastructure where the data is stored, how is accountability and responsibility shared for securing the infrastructure and user data? And in addition, how is responsibility shared in the event of a data breach?
so maybe to start off with maybe Baiju's question, then come to Mutiso's question, you realize that yes, the cloud computing services are provided for. The cloud computing service providers are available. Then how do they then maybe provide these services? How do you just go through your phone and you realize I'm able to do ABCD through the cloud? I'm able to access information. I'm able to maybe run my business through the cloud. This normally comes through the cloud computing agreements. And more or less, the main cloud computing agreements that we've seen in the business aspect of the law coming in to provide for the regulatory aspects is through the service as the software as a service agreement. So normally the law comes in to ensure that even as you're contracting to have your cloud service provider engage with you in terms of provision of the cloud, then how do they run their cloud software aspects? How do you, as a consumer, run your business whilst ensuring that the law is adhered to, whilst ensuring also that there is seamless use of this particular software? You tend to realize that the software as a service agreements have specific clauses that come in. The clauses now tend to ensure that, for instance, you have the master service agreement coming in for the initial contracting of a cloud service provider. In the master service agreement, it normally just provides for how you will engage this particular cloud service provider, the duration of the provision of the service, the costings involved, aspects to do with severability of the contract, what really comes in to ensure that you are able to terminate the contract as a cloud service provider as well as a consumer. So technically, the law basically comes in to ensure that the contracting parties play a fair game in terms of them running their business as cloud service providers. You as the consumer, how are your interests met? Now, to come to Mutiso's question, which is more or less the discussion from Baiju's insights, you realize that for the service to be able to run, the master service agreement now incorporates a service level agreement. Now, the service level agreement has specific clauses that ensure the protection of your information. They provide for the uptime in terms of how often or how long does this particular cloud service provider ensure that this service is available to you. How then is it guaranteed that the software uptime is met, whilst also at the same time there are clauses that ensure your cybersecurity in terms of data protection are provided for. So basically, as a lawyer and as a consumer, you realize when you're contracting a service, a cloud service provider, you involve a lawyer. You involve a lawyer that has the experience in terms of the tech aspects. So the lawyer then comes in to draft this agreement between yourselves, where the lawyer will ensure that aspects in terms of maybe the response time when the software is down are provided for. In terms of the guaranteed software uptime is ensured that if we agreed maybe in between from 8 o'clock to maybe 9 when the business is running, this cloud software is available. Then afterwards, maybe the technical team from the cloud service provider can do their maintenance aspects, whilst ensuring maybe throughout the day, they normally receive notifications in terms of maybe breaches, in terms of the operations, where maybe there's a technical hitch. So theirs on the other end is to ensure that the response service uptime is met, whilst also ensuring that the response to time in terms of the general support, the request for maybe maintenance, request for functionality aspects are provided for in line to how the consumer wants the software to run. At the same time, there are also performance metrics and the key performance indicators that are subject to the service level agreements. So you realize in a nutshell that the lawyer will then come in to ensure that even as they are drafting this particular agreement, all these aspects are provided for. All these aspects are catered in terms of how the law expects this the running of the software to be done. And in terms of maybe data protection, the law on the side of cybersecurity can overarch in the main agreement, from the master services agreement to the software licensing agreements to the service level agreements. All these come to interplay from the legal aspect of ensuring that even as your cloud service provider does their software items, you, whilst running your business, the law has a hidden hand, maybe, if I can use the word, to ensure that all these aspects are provided for. So technically, or basically rather, the law comes in to ensure there is a fair playing space between the contracting parties and the consumers, whilst also overarching the expectations to how this cloud service provision is run under the law. So the law is more or less a facilitator to the business. And that's where a key aspect of the law comes in through the lawyer and through the agreements and also through the specific laws that come into play.
So Simon,
Yeah.
something intrigued me while you were talking about bringing in a lawyer. Look at it this way. You know, I sit in my little IT department and I'm told, go and try the cloud out for ABCD. So I go to the cloud, I sign on. I'm thinking I sign on to Azure or AWS. And I say, hey, I'm on the cloud already, right? And there's a tick box says terms and conditions. At times I read them a little bit. After about 10 lines, I'm like, this seems okay. I click on it, I accept it, I'm on the cloud, right? I put some data on there to try out, blah, 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 right? Do you think I sitting in that tech department would have ever crossed my mind to come and talk to somebody like you and say, hey, can you check these terms and conditions out? No. So I'm saying, how can you ingrain you as a lawyer into technology? While I go there, I get a pop-up saying, look, hey, have you considered ABCD on this because it's not in line with the Kenyan law? Because you see that the hyperscalers are on the American base or the British base. Have they aligned their legal system? No. So today, if you take them to a Kenyan court, 99% of the times they wouldn't have a clue how to deal with it. Is it to our advantage as a consumer, as a driver of the cloud, or is it to our disadvantage in principle? So that if you tell the crowd here it's to our advantage, hey, happy days, everybody will be taking AWS to quote or Azure to quote, and they'll get paid very well, right? If our legal system works, correct? So is there a way, or is there a method you've come up with, your team has come up with at NetSharia to automatically assess that, this is my agreement, I match it to the regulation and the legality of it. Of course, there are certain bits which are left to interpretation, which they have to come to you. But on general, doing some basic applications will work. So for example, the best example is again to Gmail, right? Everybody bloody operates on Gmail, but do they know the terms and conditions they operate under? That's my point.
Yeah. So it's quite interesting that even for consumers, like, let me give the participants a clear example. You tend to find when you're purchasing or rather for most consumers, when they're purchasing maybe even as little or as basic as you getting your SIM card registration, there are always terms and conditions. But you find most of us really just read, yes, we go through the same, or you just rush to get to the tick box and voila, you just want to get the line. So yes, there is the danger of you not basically getting that protection you expect maybe when a breach occurs, because you didn't quite align yourself to the terms and conditions and maybe involve a lawyer. So the technical aspects, or rather where we tend to miss as consumers and even as providers, is we all tend to rush towards the profit making aspects. We all rush towards, yes, I'm signing up for cloud. They've been issued with terms and conditions. I just want the software. The legal aspects will come later. So more or less, there is the aspect of ignorance as well. So we tend to realize most of the service providers themselves, the consumers themselves, rarely or hardly ever have the time to think, how will the legal implications come in? For instance, when there is a breach, that is when we now tend to rush to having a lawyer get involved. So basically, in terms of you running your business, it is important that, first of all, ensure, in as much as the law is in play, in terms of the law has allowed this cloud service provider to operate in a given jurisdiction. So for instance, a British company coming to operate in Kenya, there is the British law that this company was established in. There is the Kenyan law that the business is coming to operate in. The lawyer will then come in terms of ensuring in the agreements I've mentioned before, for instance, in the service as a provider agreement, there are also product as a service, there is the infrastructure as a service. And also in line with Mutizo's question, you realize, yes, both jurisdictions come into play. There are different laws. There are even different data protection laws in between. So how does the lawyer then come in maybe an automatic way to ensure, even as you rush to take your terms and condition box, you're still protected? So first of all, in terms of the jurisdiction aspects, where a cloud service provider comes from the UK and is coming into Kenya to operate, there is the regulatory body that overacts the protection of use of technology. For instance, in Kenya, we have the Communications Authority of Kenya. Before this particular cloud service provider has, their operations set up in Kenya, it will ask them to provide certain pieces of information towards their licensing. The licensing itself is part of the compliance and regulatory aspect. So from the first measure, you have the regulatory body ensuring maybe the jurisdictional aspects are met. So if a cloud service provider is setting up shop in Kenya, they have already been allowed technically to operate in Kenya, lest the communication authority body or the regulatory body in this case slacks in their job, there will be a problem. Now, in terms of the consumer now coming into play, you have your terms and conditions. You're purchasing a cloud solution. You've been provided with terms and conditions. Instead of rushing to just tick the box because you want the service, you want your business to run if you're in business, or you want to use this particular software, it is quite important to involve an advocate who's savvy in terms of reviewing these terms and conditions, ensuring that, yes, much as this service provider has come into play in the Kenyan market, the details regarding the intricacies of how they'll operate, what services are they to provide, how are they to provide these services, and more so in case of breach, for instance, in terms of data protection, what does the law provide? So that is where the lawyer comes into play. Now, in terms of us as NetSharia coming to ensure that much as you've purchased this particular software, much as a service, cloud service provider wants to set up shop in Kenya, on our platform, there are specific agreements that we provide. So you find, for instance, the software as a service agreement is on our platform. The software licensing agreement is also available. So more or less, it is how a particular lawyer or even a particular firm provides this service. And it also tends to do with the aspect of specialization. You find there are firms that have specialized in different areas of the law. So you get a firm that has specialized or has lawyers who've specialized in cybersecurity, in aspects to do with the contracting of service providers, and even to the extent of having companies setting up shop in Kenya. It is obvious that for every company to set up shop in a particular area, they ought to have gone through the licensing provision body. For instance, in Kenya, it is the Communications Authority, where the relevant ministry, in our case, the Information, Communications and Technology and Digital Economy Ministry will be involved. So it stems from the government itself towards now the operations of these particular lawyers. And I'll give you an example. Most recently, rather, we've had the aspect or maybe the saga to do with the WorldCoin operator coming into play in Kenya. When the question of data protection arose, I'm sure all tech-savvy lawyers, excuse me, ran to the aspect of how did WorldCoin even come into play in the Kenyan market? And that is where the license aspect comes in. The communication, the Office of the Data Protection, or rather the Data Commissioner in Kenya, and provided proof that yes, WorldCoin was registered to operate in Kenya. But maybe how they then proceeded to do their business is where the legal aspects came in, and maybe they were in breach. And eventually we saw them their operations being stopped in Kenya. So it tends to do with, if you're setting up shop in Kenya, it is important to have your lawyer ensure that even as your business is coming into play, have you met the requisite conditions? with regard to the Communications Authority. Are the laws available? Are the laws in tandem to what you're coming to do? In Kenya, it is true we were caught off guard by the WorldCoin scenario. Most of our laws were not really, developed in terms of this particular software that these guys were using or the products they wanted to provide. So it then came to this aspect of how fast does the law evolve in terms of ensuring, yes, a particular company is coming into play, or a particular product or software or technology is already in the market. So how then is this protected? Baiju has mentioned the aspect to do with AI. It is the in thing right now. More so that as cloud service providers, they actually were based in terms of data centers. So AI is now coming in. AI will be involved in the data center business, will also be involved in the cloud provision services. But then where is the law in all of this? Our Kenyan law, much as yes, is really, really trying to improve itself. We have policies as recent as 2023 in terms of the ICT policies in Kenya, but are they really in line or up to speed in terms of the emerging technologies? It is also important to note, as I conclude, much as the technology we use in Africa and even in Kenya stems from the West, you find in their jurisdictions, the law is already developed. So even as these technologies set up shop or are becoming popular in our continent and in our country, then where is the law? Where is the law to ensure, even as a different cloud service provider or a software solution provider is originating from a different jurisdiction, as they come into play in Kenya? Are there policies? Are there even white papers to start with in terms of, yes, we anticipate AI is coming in. Is there a white paper? Is there a policy already in development towards the provision or the development of a law? Already that is how the process of the law comes in. You start with a white paper, the concept or the idea that yes, for instance, AI is coming into play, or in our case, we are adopting a lot of cloud service provision. Do we have a white paper? Yes, in the Kenyan space, already this has been provided for, because from the white paper, we then get to the policy development. I've mentioned we already have the ICT policy in Kenya coming into play. So now in terms of the law, has the law been updated? Is it up to date in terms of, yes, this is what is coming as a business, this is the solution they're providing, these are the aspects that are coming into play with all these technological developments. What are the risk factors? Are our regulations able to, provide a robust understanding of, in terms of breach, in terms of the developments, even further developments? Are we in line? Are we ready? And that is where different specializations, for instance, net Sharia, we come into play in terms of, yes, much as the law is still not connected, like Baiju mentioned, you have a company setting up shop in the UK, it's from the United States. Are there laws in line? Are there laws in tandem in terms of how they'll protect or how they'll regulate these particular two companies? So ideally, even in the Kenyan market, as the technology keeps on evolving, as we experience these changes, it is important to note, even as lawyers, that yes, there are changes in terms of technology, but where is the law? And we are normally taught the aspects to do with comparative analysis when it comes to the law. Much as we'll have no key development of a particular area in the law, we'll find a different jurisdiction that operates in the same way as the Kenyan one has already done this. For instance, South Africa is really, really quite ahead in terms of even the adoption of, fintech solutions. This is to do with maybe cryptocurrency and such. The South African law operation is the common law operations. In Kenya, this is the same. We've borrowed even our constitution from the South African one. So there is that interplay that yes, we might not have the particular acts or regulations already set up already in place in Kenya, but we can borrow and ensure that even as the law comes into play, maybe when a breach or when a conflict arises, we're able to provide precedents from the same jurisdictions in terms of provision of the law protecting these particular operations in the Kenyan jurisdiction. So yes, you might find challenges to do with the law, but ideally, we're still all covered. So it is more or less how informed a particular lawyer is.
Thank you, Simon. I think you've raised within your discussion a very interesting point has come up, where the world is going to, the use of the words AI, or I guess artificial intelligence. So I think now, based on that, there's also a question that's come up. So maybe I would like to get Baiju's insight as to where these emerging trends taking us to in terms of what's the future of cloud computing in the light of AI, that AI. And specifically, there is a question which asks, with the emergent trends in the AI space, how do cybersecurity analysts incorporate AI in securing data? This is from an anonymous attendee. So maybe you can have your insights, Baiju, about what AI is, where we are going with this. Then we can close with Simon giving us a bit of an insight as to the prevailing laws on this. Thank you.
So thank you very much. Simon, great analogies there. I must tell you, good stuff. In terms of AI, the way we see it is horses for courses, right? AI is around, as I look at it, is artificial intelligence. It's not artificial. It's sometimes real intelligence, right? To take the artificial out, it's real intelligence, right? You're using data to make some sense into information, right? And making that information smart and intelligent to work for you. It works on certain aspects. It could be purported in different ways, right? And the question is very relevant. How do cybersecurity people, or how do cybersecurity practitioners use AI? So, for example, the 24/7 monitoring, right? If a machine can monitor certain things and certain areas, and a good example is today, if you see the space station is monitored by drones, AI drones made by a Japanese company, and they go and just check very basic aspects of it. They don't make any decisions. They leave the decisions to the human, right? Or the operators sitting here on Earth, watching this or not watching it. So these are self-managing drones which go and chart themselves. They make sure that they are all driven. So that's one part of it, is building that machine capability to be able to drive, right? Or the knowledge to drive. And it's based on a set of operational data which you want to convert into information, and that information is relayed back to somebody, or you could also put in a decision-making engine, says if this is this, if that, and if it's an exception, then it comes to somebody who can make additional decisions. So that's one part of it. The trends into AI, I think it's touching every aspect of business, but also your life in terms of simple thing. When you program your calendar, your financial calendar, on the 9th you have to pay VAT. If you can program your bank to automatically pay the VAT, for example, what happens, right? That's one simple example of automating a process. Or even better, you could set up an order which says to the bank that on the 9th, whatever my VAT amount is, on my PIN number, Kiara, just pay it, for example. So that's intelligence, right? It is automation. It is evolution. It could be not called revolution. And why do I say it's not a revolution? Because I don't think it's disrupting what you do right now. The only time the disruption will come when you make a whole chain do things very differently. Very differently would be the government giving you a refund on your VAT automatically. That would be very different, right?
Yes.
Or renewing your business permit automatically, right? And you don't have to go and back to the Nairobi City Commission or Council. I say, please renew it. Please do this. Have you received the payment? All that administration work, if it's taken out, and if we use our growing talent in this country to do more intelligent work, what transpires? And again, I would say, it's to do with the law of the land, right? To support this. Unfortunately, our law doesn't support some of these things, or it's abused to a level that it's hilarious at times. So, I mean, that's one part. Now, they talk about generative AI. The buzzword going around generative AI. Generative AI is building on knowledge, building on new rules, set of permutations and combinations which are coming together and being put in practice. So what does the best practice look like? So today, if you go to ISO 9000 and they give you a best practice of how to operate, right? Now, if that best practice is continuously improved and you relate that to the Japanese on a Toyota production line who continuously improve, they'll stop the whole line to fix a problem, right? They won't wait till the problem happens at the end. Think about a machine doing all of that for you and continuously improving your process. So every day in the morning, Simon, you come to office and you will have a different set of laws to work from. What happens? Right? Because the machine has improved, it thinks faster, can identify things faster than you can at any given point. But it has to be repetitive. And a set of rules associated for them to change. Again, the legal system comes into play. So how do you automate law? That's my challenge to you, Simon.
Yeah, thank you, Baiju. Thank you for those insights. I think we're seeing, especially in the law, a lot of the, would I say, encroachment or transition towards the use of solutions or systems like the Chat GPT, to solve some a variety of legal issues and queries. Maybe Simon, based on Baiju's question, what can be done then to automate the law, and how to meet these new developments, and what can be done so that then they merge. There's a benefit. The law basically uses these new developments to better itself and to better serve the populace who are using these new technologies.
Actually, thank you, Baiju. You've touched on a very important aspect. I'm also noting one of the questions asked by one of our attendees in terms of, he's mentioned there's the aspect of, the law, rather the pieces of technology really developing at quite a fast-paced stance, whilst at the same time, you still have your SLA that was drafted. How do you then keep up? How do you ensure that, yes, much as there's machine learning, AI is already developing, where is the law in all of this? You'll tend to realize something very important, very interesting to do with the law. The law itself is not, as we say, retrospective, or rather, the law doesn't really go back. How then does it develop from that particular standpoint? towards the future. And as I mentioned, this has to do with the uptake of these pieces of technology. For instance, AI is not really ingrained in the Kenyan market just as of yet, yeah? We might find we've already developed the law in terms of, let me give you an example of the Computer Misuse and Cyber Crimes Act. If some of these offenses that we consider as cyber crimes, for instance, phishing and such, if we already have a particular list of cyber infringes or breaches or even attacks that feature illegal in Kenya, if there's a new development that this comes in, you tend to realize there's a gap that will be left in between. Yes, a business will suffer in terms of there is something that's quite new that's already developing, whilst at the same time, the law hasn't protected this. So maybe as a challenge to the legal system, there's the development of the committees, there's the development of, observatory bodies. I'm sure in terms of the ICT space in Kenya, from the Communications Authority or even the ICT Authority themselves, there is that observatory aspect of, yes, there is a team that needs to be set up in place. If this is not actually the case, because you tend to find these are internal measures, whilst at the same time, in terms of legal practice, there is the importance of ensuring we keep up to date. And by keeping up to date, I mean, if I was using, or if I'm still using a mobile phone that was manufactured in 2010, you tend to realize some of the features are outdated. Some of the features are, it's a bit slow. The phone itself is slow compared to a phone that was developed in the year 2020, or even just a newly developed mobile phone. Whilst the law tends to operate almost in the same way, you tend to realize, and in light of Mutiso's question, if my SLA or if a particular company was set up in Kenya in 2018, the laws at that particular time will operate. That is fact. Where then the developments in terms of the law comes in, you find there is the aspect of judicial activism, whereby even as you look at how the Office of the Data Protection, of the Data Commissioner rather, handled the WorldCoin saga, and even as the standing committee appointed by Parliament came into play to, provide for the legal overarching bit of how then, yes, this is a new technology that came into place. Maybe WorldCoin, by the time it was being registered, I understand this was sometime in 2018, we had the Computer Misuse and Cyber Crimes Act of 2018. Then Parliament is already involved in terms of the parliamentary select committee involved in investigating what really transpired in the WorldCoin saga. It will come out with recommendations. And as I've mentioned before, you find Parliament already has a standing committee, or there is an established committee in terms of, the developments in the tech space. The ICT authority will also have the same. And more or less, us as tech lawyers are also involved in the space. We're also, keeping up with what the law says. I can compare this in terms of a different aspect, maybe if I can go to the side. Every day, a new case is won in court. That case won in court, much as this may be appealed all the way to the Supreme Court, once the Supreme Court issues its ruling, issues its judgment in a particular matter, that becomes the law. It is then up to this particular parliamentary standing committee to conjure up a new set of recommendations, just like the way they did with the WorldCoin scenario. These recommendations would then be developed in terms of a bill. And then this is brought to Parliament. It is discussed upon. We have public participation. This is then where, the tech savvy guys, the lawyers ourselves, we then provide our insights. This is normally done on a daily basis through the lawyer service body, which is the Law Society of Kenya. We are provided with information to do with.
Sorry, Simon, you seem to be breaking
there
up.
are.
You're breaking
Sorry,
up, sorry.
You then realize, rather, we're provided with information to provide insights to the new developments in terms of the law. So we then keep up with, this is how we keep up with the law. This is how we ensure that we keep providing for insights, we keep providing for new information and providing for the development of the law to keep up to date. So yes, the pieces of technology keep on changing, and this is then how the law is able to evolve itself. That yes, much as we'll have an article, or rather we'll have an act of parliament that seems to have been done way back, if you have an agreement that was done in a particular year, that is the law that will apply. And lastly, you then find in these particular agreements, as you're contracting, as a business, as an individual, in terms of the terms and conditions, we normally have the aspect of, or rather the clause to do with the governing law. Normally, if it's to do with Kenya or maybe a company that's coming from the outside, we agree in between ourselves, and this is captured in the agreement, that in case of a breach, the governing law will be Kenyan law. Then, if the Kenyan law was done in 2018, there is a new development in terms of this particular agreement. Definitely, much as we have the governing clause, we have the governing law clause, we have the dispute resolution clause. The dispute resolution clause captures that in case of a disagreement, we then seek to take this through a court of competent jurisdiction. In this case then, much as the law was mentioned back to do with maybe 2018, as the case is being appealed and such, we will then come to the apex court, which is the Supreme Court, and realize, yes, this law or this agreement was done in terms of a previous set of laws. There is the new practice aspects that come into play. And I'll give you a very clear example. There is the aspects to do with emoji, using of emojis in contracts, such that in a particular interesting case, one of the contracting parties gave the thumbs up emoji. And the question that then was, can a thumbs up emoji be used to, interpret that they agreed to the particular agreement or to the contract itself, you see? So much as the law maybe back then didn't even recognize the aspects of emoji, as the case is being adjudicated, you'll realize there is the aspect of judicial activism, there is the aspect of borrowing from different jurisdictions, and at the same time, we then get to a particular case that was decided, and then it becomes the law. So it then goes back to the law development body, which is Parliament, for instance, to then implement this law, and the judiciary will then exercise the aspects of interpretation. So more or less, we are all still covered. It just tends to, come or boil down to the aspect of how fast are we. Over to you, Jomo.
Thank you, Simon. I think thank you very much for those insights. As we come to a close of this webinar, just there are 2 points which maybe make this a bit more practical for those who are listening in. A question has been raised as to how often an organization would need to review and optimize service agreements with cloud vendors, and can these SLAs keep up? This is considering the emerging trends and the speed of technology advancement. So maybe we can look at that quickly from the point of view, both the legal point and the practical point. Maybe, Baiju, you can tell us, how often do you do this as an organization? And then someone can advise us what's the best practice.
In terms of review of our agreements, generally we do it once a year on the changes, because once you sign, you have a signed term or contract. So the legal aspects don't change on that contract, right? And then when we revisit it, it's on a need basis these days. Of course, the laws are changing, the legal aspects are changing on a regular basis. Of course, we harass you guys at Net Sharia every now and again, you know that. But it's a continuous process, and you have to keep up to date. So today we have a contracts database which tells us that if there is anything which has changed, do we need to speak to a lawyer, or do we need to look at it? Is it regulatory? Is it operational? So we look at it in that aspect from our side. Thank you.
And Simon, maybe that's just a quick pointer on that. How often should this be done? How often should those reviews be done from a good practice perspective?
Ideally, these reviews ought to be done on a regular basis. Now, in terms of maybe an already signed contract, and this is now to do with you've contracted a particular developer or a particular solution, you already have an SLA in place, and the law changes abruptly. This is then where we'll have to, have the aspect of an addendum to the particular agreement. We sit down once more with the client. We provide for the changes that have been captured, or the concerns that have been captured. We definitely note they are, they are relevant. So we then sit down with the client and we construe an addendum to the particular agreement. The addendum simply then captures the new developments and is more or less similar to what is provided in the main agreement, only that now this addendum still forms part of the initial agreement, but with the new developments and the new changes that have been effected. So you can always do an addendum if there are changes that have been, noted by the client, or maybe a change in terms of the law, or any aspects to do with maybe what a client notes was left in the particular main agreement.
And thank you, Simon. So as we bring this to a close, there are two questions that have come basically on the issue of the use or adoption of AI in matters of healthcare. There's one by an anonymous attendee who says is asking, how ready is our legal framework on matters of AI in the healthcare? Because this is an area, AI is quickly being adopted, and many are coming into contact with this technology in the advanced hospitals. And then Emmanuel Garambe follows up, because I've had people having side effects from these healthcare technologies, but they cannot at all get any support or help, and they have to live with it. So maybe I'd like to just get insights of both Baiju and Simon. Maybe one from a practical perspective. Baiju, is your company dealing with any developments on AI in healthcare, and what is the progress in terms of this adoption is being asked? And then Simon, you can tell us what the legal framework around this basically is. Over to you, Simon.
Let me. I'm thinking how best to answer this. I'm reading the question. I think I'll take it from a data protection side. We've just done some work for one of the large hospitals on helping them finish up a data protection outline, and of course, AI comes up again. It's around what data is has the customer signed off? Alignment to the data protection side of it. Putting up the hospitals, for example, in healthcare need to put up their processes and change their processes as well. What we see and what we continuously see in some of the most advanced hospitals in this country, you're still filling in the forms, still signing the forms. Simple thing, entry at the gate, you might have to fill in a book, right? That's a data protection breach straight away, right? So that's one part of it. Their AI could be built in, and the cameras and all sorts of things which could be brought in. And as Simon walks into one of these hospitals, says, "Hey, Simon, you're so and so, and we have your data." Or if you're new, then you're sent to a booth and where you can register privately, right? To the hospital. Yeah, you can register as a guest, or you can register as a patient, or a doctor, or a stakeholder, or a supplier, right? So that's a public space, right? A hospital is a public space, private or public, but it's public space. You're allowed to go in, right?
Yes.
So that's one part. Now, if you put together an AI aspect where from an AI point, you're getting your photograph taken, or you're going through a scan, and the AI aspect of healthcare technology is looking at your scan and saying these are the problems to the doctor, right? It brings up 5 or 6 issues. The AI bot or the AI piece of software is not going to tell you this is the way forward, but this is what is being brought up, right? And then adapting, is that data now available to whom and where, right? And who is allowed to consume it? So if you can be draconian and you say the doctor can't consume it, first the patient has to consume it. What will the patient consume? They don't understand. Correct. They're not the expert. Why do I go to a lawyer? Because I don't understand the law. So the lawyer is the expert, right? Very similar. So those are the parallels I would draw into this. Yeah. Thank you.
Simon, over to that, yes.
Actually, if you note, maybe I'll give 2 practical examples. You've noticed in healthcare, yes, there is a lot of developments in terms of AI coming into play, even in the legal space. Most recently, we had a Kenyan developer providing the Wakili AI solution in terms of provision of legal services to Kenyans. So I would like to bring us back to the aspect of machine learning. Machine learning, if you've ever interacted with a website and you've been asked this question, maybe before you continue, identify a motorcycle in the pictures provided. Have you ever asked yourself, where does this lead to? Actually, that is now part of maybe machine learning, and in terms of this particular information you're providing is what will be used to teach AI. Yeah, so more or less, AI is actually just a development of what we actually know as human beings, but now being automated to now become the part of artificial intelligence, which is AI itself. So it stems from what we as human beings know in our everyday life, and then being translated to AI to make it more seamless to use and such. So from the idea of how then we can provide for solutions, maybe when there's a challenge to this, it is also most important to note that these particular systems that are being developed as AI are not ideally as 100%. Yeah. So they're still work in progress. I tend to believe, yes, the idea of us seeing AI becoming sort of more superior to what we practice on a day-to-day basis is simply because it is more effective to use. It is more seamless in terms of its use. But then it still boils back to what then will a human being provide as a solution? As Baiju has mentioned, even if the AI prescribes a particular medicine or prescribes a particular dosage, it will still be up to the doctor to then know this is now the right track to follow. Because even on the Wakili platform, much as somebody will use it to, get a legal solution, it will still be up to them to know this is where, or this is how far this can be applied. This is how far this can be involved to get to a particular solution. And lastly, I'll just give an example of ChatGPT. More recently, I saw somewhere a graduate giving thanks to ChatGPT, actually a law graduate giving thanks to ChatGPT for, taking him through law school. I get to understand maybe this was through the assignments it helped him do. But you then realize, even as much as ChatGPT provided this particular information, ChatGPT themselves, if I'm also up to date, the last bit of how recent in terms of its information scope was in 2021. What if a law was developed in 2022? It then boils back to this particular student or user to realize that yes, much as ChatGPT gave me this particular solution, I'll still have to now do the omission of what's relevant, what's keeping up to date with the new developments in terms of the law, and apply it. So it still boils back to the practicalities of, yes, this is AI giving a solution, and how then is it relevant to the everyday practice of maybe in terms of healthcare or even the law itself. So it's a space we ought to tread carefully. Yes, AI is there. It's actually there to provide for an efficient solution because it is faster, it is seamless, but then is it really applicable in the current or in its very raw form? I'd like to put that question to our viewers. Thank you, Jomo.
So, Simon, thank you, Beiju. We are coming to the end of this webinar. We thank you for having been with us, for the questions you've raised, for listening intently. We have just gone over by a few minutes, but basically would like to thank you for taking your time out to attend, to be with us. We'd like to end with a short video about Net Sharia, focusing on its Entrepreneurs Club, which is a service through which that the populace can get packaged legal services at a convenient monthly retainer fee. We'd wish you a good rest of the afternoon. You may raise any questions you have to an email info@netsharia.com. You're also welcome to visit the NetSharia portal at www.netsharia.com to view the services. And we wish you a good rest of the day and a good rest of the week ahead. Thank you for joining us and have a good day.
Thank you very much.
Thank you, Baiju. Thank you, Simon.
Just a quick reminder to all.
Yes.
We are offering a free cloud assessment. If you want one, just go to ibiashara.com, info@ibiashara.com. We'll do a free cloud assessment for whoever attended as our thank you for spending time with us. Thank you.
Thank you, Baiju. Thank you for that offer. Welcome all the attendees to take up that offer and engage with the Ibiashara services as on its website. Thank you very much. Again, we'll end with this short video from NetSharia.
Thank you.
Hi, my name is Ron Mulamba, a product manager, and I'm here to talk about the exciting new features on the Netsheria International site. A lot of individuals and businesses out there open themselves up to legal risks by using outdated legal documents when doing business. This can be intentional or unintentional, as getting a reliable source of up-to-date legal documents has been a challenge in the past. But Netsheria International is here to change this. Through the Legal Documents portal, you can now access frequently updated legal documents without having to visit a legal firm. Let's go on a journey through the Netsheria International site. First, type netsheria.com, click on Legal Documents portal, and select your preferred category of documents. From there, you'll be able to select your preferred available document, view its details including the summary and table of content, and purchase it either through M-Pesa or card. You'll receive the documents link via email, which you can use to download the purchased document. It really is that simple. Netsheria International, your lawyer on your laptop.